Alex, do you remember the Davy Donuts case you were helping me with? Take a look at this. The judge ruled, and it was even better than we had hoped. Judge Silver refused to acknowledge the amended complaint filed by the plaintiff the morning of our hearing and dismissed the original complaint with prejudice. To top it all off, the judge ordered sanctions against the plaintiff for trying to amend the pleading at the 11th hour. When I made that argument, I didn't think the judge would actually order sanctions, but I'm glad she did. It was a total home run ruling, and the client is ecstatic. But the case isn't over, though. Not surprisingly, the plaintiff filed a notice of appeal. I looked at the case law, and there's well-settled law against the ruling the judge gave us, particularly the sanctions portion. But I need your help drafting a brief to defend the trial court's ruling anyway. The client is very important to our firm, and we need to try to make this stick.
This does sound like a great result, for now. But how can we defend the trial court's ruling if there is law to the contrary? Isn't this just opening us up to exposure for filing a frivolous argument? Should we not just think about conceding error now?
I don't really see a concern. I mean, look, judges are smart, and their rulings are presumptively well-grounded and correct. Attorneys have to stop filing things at the last minute after matters have been pending for months. Sometimes judges don't get everything perfect, and that's why appellate courts exist, but their analysis is not groundless. I mean, if a judge said it, then it's defendable, right? We are not cross-appealing here. I mean, we are just defending what our learned judge said, even if the law is a little bit different. Maybe the other side will do a poor job on their brief, or the Court of Appeal won't look too hard. If we get this affirmed, we are heroes to our client. And if the Court of Appeal finds the law I mentioned and reverses, then so be it. We're no worse off than had we conceded error, am I right? We owe it to the client to take our shot. It's called being a zealous advocate.